We're going to go right into this next session, which is updates on college athletes, NIL, and celebrities' right of publicity. And just very quickly, because I'm going to hand it over to them in a second or two, our three panelists for today, we have Ron Katz, the author of Sport, Ethics, and Leadership, and also a longtime IP practitioner. Jeffrey Orridge, who is the Chief Executive Officer at TVO Media Education Group. And then I saved him for last because he's basically going to be both panelist and moderator, Jonathan Goins, who is a principal in Lewis, Brisbois, Bisgaard, and Smith. And of course, a proud Howard graduate class of 2002. So one of the early ones who helped to get all of this off the ground. So with that, I'm going to just hand it right over to you, Jonathan.
Thank you, Professor Mtima. We appreciate your ongoing social engineering for this IPSA program, and we want to give you your roses now. So again, let's give a big round of applause for Mr. Professor T. So thank you so much for inviting me. Mr. Katz, if you've heard him before, you know he is very passionate about the NCAA. And so in due deference, we're going to let him go first and give his take on the NCAA and some issues that he wants to make sure everybody knows about. So without further ado, Mr. Katz.
Okay, thank you, Jonathan. The subtitle of my talk today is "Greed is its own revenge," and it will become obvious why that is the subtitle before too long. I could actually summarize my presentation with one number, and that number is 1.3 billion. 1.3 billion is the revenue of the NCAA last year. So I would challenge anyone in the audience to tell me of another amateur organization that has revenues of $1.3 billion. Also, most of that is pure profit because they have one of the most brilliant business strategies ever conceived, and that is they don't pay their employees. So I'm sure any of you who run a business could do much better next year if you decided not to pay your employees. And the thing is, they've been getting away with this for years. But there's more. And the more is that's about half of it, because the college football playoff is a separate organization now from the NCAA, because these big, powerful schools did not like the idea of sharing revenues with the smaller schools, who probably are amateur. And there's another, starting next year, there will be an additional $1.3 billion each year for the TV rights to that. So we're talking about an organization with $2.6 billion a year, or college sports getting $2.6 billion a year. And I'm proud to say that because of IP law and because of antitrust law, that has started to change. There were a couple of very important cases, the O'Bannon case and the Alston case, basically antitrust cases that had to do with images. And if you talk to any antitrust lawyer, they will tell you it's very, very hard to win an antitrust case. And the only exception to that is if you file a lawsuit against the NCAA. Because the NCAA, they always lose. They always lose, and they lose big. And they always keep doing the same things. They always keep saying, oh, this is all about education. We're not really a business, etc. And I don't know of any educational achievements of the NCAA. Quite frankly, I'd be grateful if somebody would tell. Well, actually, I do know one. I think they did create the concept of one and done, if you want to call that an educational achievement. In fact, it's really one half and done, because when you think about it, if a basketball player passes the first term, he doesn't really need to pass the second term in order to collect his money from the NBA. So and then after these cases, there were statutes by the states, and which said that the obvious, that athletes, college athletes, like everyone else in the world, were entitled to receive money for the thing that certainly, if you own anything, you own your name, image, and likeness. So we're in a new world now. We're in a world where they can get paid for name, image, and likeness. They still can't get paid a salary, although that will change soon. And what is this new world like? Well, one of the big aspects of this new world are these things called collectives. And what a collective means is that you want your university to have a winning team. And so you get together with a number of rich alumni and you pay recruits for their images, and you pay them millions and millions of dollars. Now, in one sense, this is just old wine in new bottles. We used to call them boosters. Now we call them collectives. But since it is legal for athletes to receive money, collectives now have a couple of problems that they didn't have before. One is it's sort of very shadowy what they do. So we've had a case where somebody made a deal with a collective for $13 million, and the collective reneged. And then the question becomes, well, how do you sue? How do you sue on the shadowy organization that's operating under shadowy rules? Even more important are the tax laws. The tax laws always, I mean, they nailed Al Capone on the tax laws. And that's what always ends up being the deciding factor. So if you want to give a contribution to Howard University to support Professor Matima, for example, you get a tax deduction for that because that's a very noble cause. But what if you want to give a contribution to a collective so they can pay millions of dollars to a star athlete? That really is not the same sort of thing. And the IRS is definitely going to crack down on that, and that's going to change the world. I mean, just by the way, another way that the world will change is when the college athletes start collecting salaries, which I don't think will be very long because the NLRB has just ruled that the Dartmouth basketball team can unionize. They're also going to have tax liabilities. So you're going to have these 18-year-old kids. I mean, I remember when I was 18, the last thing that I would have ever wanted to do was to fill out a tax return or to even know how to fill out a tax return. So although if you're making $8 million, you probably can find somebody to help you fill it out. I will say that. So that's one of the big results. And another question, an open question, is what effect will this have on Title IX? Because Title IX has been one of the most successful civil rights laws of all time. When it was passed back in the 70s, there were about 300,000 female college athletes, and now that it's in the millions. So it's been very successful, and it's been very strictly enforced. But how do you enforce Title IX against a collective? I think it's safe to say that these collectives are going to be given more money to the sport of college football than they are to the sport of field hockey. So since field hockey is mainly played by females and football is mainly played for males, there's going to be a huge variance. And how is that going to be dealt with under Title IX? Are we going to lose some of the progress that we've made under Title IX? The similarity now between college sports and professional sports is so great that you have athletes. In fact, she just decided yesterday that she would go pro, like Caitlin Clark, very famous basketball player. She almost decided to stay in college because she can make as much money in college as she can in pro sports. There's really, and that the fact that she was making that choice, and I'm sure money was a big factor in it, shows that the distinction between pro sports and college sports has really disappeared. So what is the role of the NCAA now in all of this? Basically, because everything the NCAA does seems to be an antitrust violation, they have to be very, very careful. And they decided with respect to NIL, name, image, and likeness, they were just going to give up the ghost. They were going to tell all the colleges, you just make your own rules. All the conferences, you can just make your own rules, with one exception that I'll talk about in a second. And then the other thing they do is they go every month or so to Congress and beg Congress to give them immunity from the antitrust laws. You know, we've got war in Ukraine, we've got war in the Middle East. I'm not sure Congress should be focusing on helping an organization with $2.6 billion a year in revenue to avoid the antitrust laws. And so far, they've met with absolutely no success in that. And then they still have a few tacky rules that relate to recruitment. They say one thing is for sure: when you recruit somebody, you cannot talk about NIL. That is the one rule we're going to say. You just can't do that. But it doesn't make any sense. If you're an 18-year-old star athlete and you're thinking about what college you can go to, and you know you can make millions of dollars, what is the first and only question in your mind? How much money can I get? So it's sort of hard to talk to the colleges without that coming up. And of course, the colleges would never say something like, well, if you come here, we'll give you $8 million. But what they do say is, well, we're so happy for our current quarterback. He's getting $8 million. So if you're a quarterback and you see that the current quarterback is getting $8 million, maybe you'll get the idea. And in fact, there's a case in Tennessee. Tennessee, another tacky rule that they are trying to enforce is you cannot provide a private jet for a recruit to come to talk to you. Well, I mean, if you're talking with somebody about an $8 million contract, you really wouldn't expect him to show up on a Greyhound bus. So the idea that you're providing a private plane, I mean, it's trivial. Compared to the $8 million, it's trivial. But they brought that case against Tennessee, and Tennessee did not react very well to that. The state of Tennessee, because it was the University of Tennessee, a state institution that was affected, the state of Tennessee actually has brought suit against the NCAA, and they were joined by the state of Virginia. So that's a pretty serious problem, because since the NCAA loses all of its antitrust suits, it's a very serious problem. And of course, having states sue you is a doubly serious problem. And in fact, the judge has enjoined the NCAA from enforcing its rules for the time being. So the NCAA really is not long for this world. Another aspect of this is the video games. The Electronic Arts, which makes the Madden game, also used to make a college game. And again, the law stopped them from doing that because they had the same business model as the NCAA, which is let's not pay the athletes. Now they have an offer out to the athletes. We're going to pay you $600 for the use of your image in our game. Keep in mind that EA makes billions of dollars from these games. And there's 11,000 college football players. So if every one of them got $600, it would be $6.6 million, which is a drop in the bucket compared to what Electronic Arts will get. And of course, the top players are not going to accept that because they're worth much more than that. In fact, we have a model for what this is worth, because when we look at the professional athletes, they're all represented by unions. And as I said before, there's no question that unionization is coming for college athletes. It's already here at Dartmouth. And basically, they get half the revenues, half the TV revenues, and they get about half of the revenues from the video games, which amounts to hundreds of millions of dollars. And that is really a fair share, if you ask me, because basically it's the athletes that are creating the value. So, so that 1.3 billion or 2.6 billion, I think, is going to be halved in the near future. And that's why I entitled my talk, Greed is Its Own Revenge. Thank you.
Thank you, Ron. This concludes the right of publicity update. I think Ron just covered everything. Jeffrey, I don't think we need to talk any further. All jokes aside. Oh, question. Yes,
I have a question for Ron. I'm not sure. I don't think you like the NCAA very much. Is this ideologically, or is it just the way they view the laws?
Well, I think that their legal record speaks for itself. I mean, I was a trial lawyer, so it's liking people or disliking people. The moment somebody walked into my door, I knew who had to win the case, whether I liked them or not. So liking has nothing to do with it. I think their conduct is reprehensible. But I think the idea of not paying your employees is reprehensible. So, but it has nothing to do with liking or disliking.
Jeffrey.
I just want to chime in on your comments and what Ron was saying. So taking us back, the NCAA was founded in 1906. And the principle behind the NCAA was to protect the athletes, to protect student athletes. And I think, not to speak for Ron, but what I'm reacting to as well, as I'm aligned with Ron, is that what has the NCAA done to protect the rights of the student athlete? And that is the issue, that it is almost antithetical to what their founding principle was, as it has transpired over the course of history. And now I'll go back to my seat.
All right. So try to keep us all in the same view, trying to get my clicker to work. We did have a few slides so that you all get CLE credit for those of you who need it. All right, there we go. So we keep talking about NIL, and I think it's important that we are emphasizing the IP. I'll get to social justice in a second, but I think it's important that we're emphasizing what exactly is the IP at issue when it comes to NIL. Name, image, and likeness. Obviously, it's birthed out of the right of publicity. We all have a right of publicity. We're all born with the name, image, and likeness. That's a given. We don't have to have a registration like a trademark in order to proceed with suing someone. It's not a standing issue. We already have it. And so when people talk about NIL as if it's a new concept, it's not. It's just the latest, greatest, different coined way of talking about right of publicity. So I think it's important that we continue to emphasize that it's truly birthed out of something that's already been existing for a long time. And so that's a given. What else in IP is relevant to NIL? Well, without a question, it's a trademark. If you're using your name in a particular product or service, your image, your logo, it's a given that athletes and celebrities are beginning to take advantage of taking their NIL, registering it as a trademark for additional ability to enforce such likeness should there be unauthorized activity. And we've seen this has been done for decades, but it's just now getting more attention because of all of the Ed O'Bannon litigation that we see in the media. Tiger Woods did it in the Sixth Circuit. He asserted his name, image, and likeness in addition to his trademark rights in trying to sue Rick Rush, the artist who had done a portrait of him, sold that portrait for dollars, and Mr. Woods didn't take too kind to that. Same has been done by Michael Jordan, the Seventh Circuit. He successfully sued Dominic Foods for using his name in connection with the selling of a coupon for Dominic's steaks. And he got a jury verdict of exactly what he said that he would give if you did have his permission. So he said, look, the average endorsement deal that I do is $10 million. And guess what? The jury verdict was $9.8 million. So when Ron talks about are athletes going to accept $600? Hell, yeah, depends on which athlete you're talking about. Someone who's barely, in the mix of making a team may be okay with that, but obviously the superstars will not. And then last but not least, obviously, are also copyright issues, which continue to be kind of a moving target because it depends on what kind of context that you're speaking to. And it's anything from digital aspects to traditional TV and broadcasting rights, to merchandise, to clothing, to uniforms. The Supreme Court a few years ago in Star Athletica has now recognized that cheerleading uniforms are registrable as a copyright. I'm sure Ian knows well about that, given his copyright expertise. So there's a myriad of issues that we have to pay attention to when we're talking about college professional sports, the sports industry as a whole, the entertainment-related industry. It's an evolution, but it's a triangular aspect from a legal standpoint as a practitioner from my end, because you've got to look at the right of publicity aspects, then you've got the trademark aspects and the copyright aspects. And a lot of times that gets confusing because you're getting hit with NIL issues and you're trying to figure out how best to advise your client, and that can be somewhat difficult. So when I mentioned athletes' logos, these are just a sampling of some in which they are using their likeness for commercial merchandising profitability because they're trying to expand upon their brand. Talent are becoming much more sophisticated in understanding how they can use their own persona rights towards making deals happen. So whether it's Tom Brady and TB12 or Tiger Woods, you see the TW, Shaquille O'Neal, you see that person, the silhouette dunking, Michael Jordan, obviously, the main silhouette in the middle. You see SF, that's Steph Curry. There's at least a dozen different famous athletes whose likeness they use in an exploitive commercial manner. So when they're doing potential endorsement deals with a Fortune 500 company, and that Fortune 500 company says, hey, you need to endorse our product or our service, and we need you to wear this, or we need you to put on that, the athletes are getting more sophisticated. They're saying, okay, I'll do that, but guess what? I also get to include my logo. So we're going to do a co-marketing deal. We're going to do a co-branding deal as if the athletes are also a Fortune 500 company. So just be aware that those kind of business acumen aspects are happening in real time right now. Ron did a great job of talking about what was with the NCAA and what they would not. Oh, let me go back one more time real quick, just to acknowledge something on this week. Ron is right. There still is no NIL national legislation that has passed. And by default, there's also no federal right of publicity law. So certain states have right of publicity statutes, obviously. Even Tennessee, most recently, has now adopted the very first state right of publicity law that recognizes AI aspects to your likeness. So if your likeness is being used by AI through someone else, obviously, without your permission, according to the state of Tennessee, they now have legislation that has passed in which they're using AI as a component to your likeness. Yes.
Question. So is that in the AI context, is that removing the traditional right of publicity requirement that the use be commercial in nature?
I think so. I think so. And we're only talking about the state of Tennessee.
Right.
Yeah, I think so. So the instance where, as you may recall, Drake being upset because AI generated his likeness, his voice, and basically sampling one of his popular songs. That is precisely what the state of Tennessee and the legislation that they're trying to implement is handled to address.
Because you might not be able to demonstrate the commercial application.
Correct. And now, of course, the dean of all right of publicity laws here, Professor M. Tima, is getting at the commercial misappropriation element. It's not enough that you just didn't approve of the use of your name, image, and likeness, most state statutes or common law right of publicity, they make you also prove that it was used in some commercial context. And that's where you see this tension with the First Amendment defense, because then if you're on the flip side of that right of publicity claim, the defendant is saying, well, no, it's fair use. First Amendment is a communicative expression, educational use exception, cultural commentary. You get into the First Amendment aspects in that regard. Ron also talked about what is right now. And that specifically speaks to these collectives and boosters and the fact that a student athlete, if you want to call them that still, is not supposed to be recruited or solicited on the basis of a collective or booster club enticing them with an NIL deal. And so to Ron's point, just last week, Judge Corker in the Eastern District of Tennessee granted a preliminary injunction in favor of the state of Tennessee and the Commonwealth of Virginia that basically struck down that NIL booster rule from the NCAA. So when Ron says the NCAA continues to lose, he's absolutely right. They've lost again. So you can only imagine that if the state of Tennessee and the Commonwealth of Virginia have successfully won against the NCAA. So basically what happens now is if you're a student athlete and you're thinking about going to the University of Tennessee, you can't actually know now what your potential NIL deals are going to be. Judge Corker said, look, it is price fixing because you want the student athlete to join your university, but you're not telling them in advance what their NIL potential is going to be. That's price fixing. That's monopoly. That's a cartel issue. And that's actually the word from Justice Brett Kavanaugh. He called the NCAA a cartel. So yeah, be definitely aware of that decision because it's going to have a drastic impact on recruiting. No question about it. I'm going to stop here and let my friend Jeffrey kind of talk for a few minutes here.
I don't know if there's anything left to say. I mean, between Ron and Jonathan, I think they've covered it all. So, but I have to tell you that I don't know if any of you are familiar with my background because I'm obviously the new kid on the block. So I get to comment on their comments, which is great. But my bio, I actually, although I went to Amherst College and Harvard Law School, like Professor Matima, in full disclosure, I moved up to Canada about 17 years ago. So I'm both American and Canadian, which means I can be both arrogant and apologetic at the same time. So I just want to, set the table for everybody. I'm also not a practicing attorney anymore. I'm on that 12-step program. And as a CEO of a multimedia company, I actually get to play one on TV if I want to. I warned you, arrogant and apologetic at the same time. There are a few things that have been noted already. And I want to take you down a slightly different path because I am in media. The reason why we're talking about NIL and the reason why we've been talking about athletes' rights to get paid for their performance is because it's big money. Sports, amateur sports is big money. And that's why it's a big deal. It's interesting because it was announced, I think just in January, that beginning September 1st of 2024, ESPN and the NCAA have reached another 8-year media rights agreement. Now, the rights are to 40 NCAA championships, 21 women's, and 19 men's events, exclusive coverage of women's basketball, women's volleyball, women's gymnastics. So great progress in terms of gender equity, softball, basketball, football. Also what's notable, since I'm Canadian now, are the international rights to 40 championships for D1, Division I basketball. And that's significant because of how much money there is involved because of the promulgation, the spread, the popularity of basketball around the world. And so that's important. Once again, what this really talks about, this deal, is 24,000 college games with 20 conferences. That means 2,300 programmable hours. So if you think about the money that's generated from advertising, cable subscriptions, streaming subscriptions, that amounts to a lot of money. And that's why programmable hours are really important. I grew up in a time when there were 3 networks: ABC, NBC, CBS, and maybe 1 or 2 channels in New York, like WPIX and something else. And I remember a time when there was actually a color bar that would come on the screen after their programming schedule was over that day. So about 1 o'clock in the morning, there'd be this color bar, and they wouldn't resume programming till like 6 in the morning. Now, obviously, you've got a proliferation of channels, which means there's a proliferation of dollars being generated. And that's what this is about. I don't want to harp on that more than just that statement. I think there are 3 things that I think are particularly notable in terms of the media rights. And NIL, for you all, provides another opportunity. It provides another avenue of monetization for you to apply your skill sets and your services, particularly in the diverse community, where we did not have access before. When I was, so in one of my past lives, I was director of global sports marketing for Reebok. And I was responsible for all the elite athlete endorsement agreements, everything from Shaquille O'Neal and Allen Iverson, and Maradona in soccer. I actually, thank you, I actually signed Ed O'Bannon out of UCLA to his first endorsement deal with Reebok. Shaquille O'Neal, the Dunkman logo that you mentioned, had I had representation from Professor Matima and not been working for Reebok, I would have been getting a cut of the Dunkman logo, because guess who helped create it? I'm not saying I did, but the point is, I've had a lot of experience, a lot of practical hands-on experience with the evolution of athletes' rights and monetization. And I'll take you back one step further. When I was counsel for worldwide marketing and advertising for Reebok, before I became director of global sports marketing, I was also responsible for looking at high school athletes. And we're very, very aware in the shoe industry, in the athletic shoe industry and apparel industry, whether it was Nike or Reebok or Adidas or any other player, that there was compensation being exchanged. There was value being exchanged. There were times when I was aware that guys would show up at the Rucker tournament in New York City with cases of basketball shoes out of the back of their truck. And they'd go out and hand them out to 12-year-old kids, 14-year-old kids, 16-year-old kids who were still in high school. And they'd be getting gear and apparel and all of that. So it's really interesting now that some of these things have surfaced. It's also surfaced that there was obviously, an FBI sting several years ago with some notable college coaches on their recruiting practices, that they were paying kids under the table to come to their schools. Now, what I think is interesting, what Jonathan and Ron have talked about, is the fact that, so now there is an issue about being able to entice athletes to come to your school based on compensation. That's always been the case. The issue that I see that's more pertinent is, how do you enforce it? You can say you can't have these conversations. If there's no evidence of the conversation, how is it going to be enforced? So I'm saying those are the things that, on a practical side, which is what I'm speaking to, not the academic side, not the legal side, but on the practical side, on the ground floor of what I have experienced in the evolution of sports marketing which includes apparel and consumer products, as well as media rights, as well as gate revenue. Something that was interesting, that when I think it was California that decided, they were the first state to decide that they were going to allow athletes to receive compensation for their name, image, and likeness. And it was supposed to start in September of 2021. So Florida decided that would give recruiters an unfair advantage. So the best athletes are going to go out to California. So instead, we're going to allow the same legislation in our state to start in June of 2021 before September. So I think that's the other thing. So there is an incredible amount of competition among the states to recruit these athletes because the value of their performance is so incredibly important. So those are basic things I wanted to touch on. And once again, the Ed O'Bannon case, which I believe was seminal to a lot of this, and clearly was right of publicity and antitrust involvement. But it was, Ed was one of the most mild-mannered people that I knew. And the fact that, it wasn't enough that there were shoe companies who were actually, and other endorsers who were actually trying to do the right thing for professional athletes. I think it's about time that amateur athletes are being compensated. The question is, how low do you go? This pertains to college athletes. Will high school athletes, will there be legislation in various states regarding high school athletes? Because high school athletes garner an incredible amount of attention. High school games, so my son went to Mount Verde Academy to play baseball, not basketball, because I'm 5'8" and he's only 6 feet. But Mount Verde Academy typically has their high school students. They've won 9 out of the last 12 high school championships. Their high school players, the starting 5 or the first 7, usually go to college and it's one and done, and then they become pros. Well, the games for Mount Verde are being televised on YouTube. Somebody's making money. And it's not these high school athletes, although they are 17 and 18 years old. They are franchise players. They will one day matriculate to college, and they'll probably just be in college for a year. But at what point do we start thinking about compensation, and at what level? Where's the social justice? And the more rights, the more valuable rights become, the more those charges, those costs are going to be conveyed to the consumer. So the democratization of sport as we know it now, with the proliferation of sports channels, and one of the things that ESPN and the NCAA said in their press release announcing this new deal was that the deal will increase visibility for college athletes in dozens of championships across all 3 NCAA divisions. The code for that is the more exposure these athletes get, the more profile they get, the bigger their brands become, the more valuable they will be. So this is a good deal, not for ESPN, not for the NCAA, but we want to highlight it's a good deal for the athletes.
Yeah, that's right. And I think it's probably goes without saying, because I know we all get it here in the room, but just in case, how can you put social justice in the same context as, multi-million-dollar athletes? And the answer to that is because, one, there's a different form of civil rights that is happening right now, or an additional form, I should say, via intellectual property. And this issue of justice for individuals and talent, disproportionately Black and brown folk, has not been anything new. It just so happens sports happens to be the latest and greatest attention that it's getting. This all started in music back in the 1950s, 1960s, 1970s. Black and brown artists who did not have attorneys signed work for hire agreements with record labels, signed agreements where they got a lump sum payment. They got an advance, but then didn't get any royalties, didn't get any ownership rights to the copyrights, didn't get any percentages from the royalties of publishing. And so slowly but surely, as a result of more recent success among talent, and that's why you still see even the likes of, we don't even have to make this a race issue, Taylor Swift. She's been in litigious battles over the rights to her wanting more royalties and more percentages over her first album. And so I don't think that athletes are asking for anything they don't otherwise deserve. And Ed O'Bannon in particular is certainly at the forefront of social engineering that trend. Ron, you've been too quiet for a few minutes. We appreciate you allowing us to have our takes. I want to turn it back to you, though, and ask you if you have any comments you want to close us out with, and then we'll take the last 5 minutes for Q&A.
Well, 2 comments. I mean, I also know Ed O'Bannon, very, very fine person. And he was at the top of his field. I mean, we live in a capitalist society, and you would expect someone who was at the top. He played on a UCLA championship team. He played in the pros. Unfortunately, he had some injury issues. But he was a great player. And they used his image. They sold video tapes of the championship game. And they kept selling them even after he graduated. Well, how were they protecting him as a student? He'd graduated already. And he ended up selling used cars in Las Vegas. And I'm not saying there's anything wrong with selling used cars in Las Vegas, but it's not something you would expect somebody to be doing who's at the very top of his field. You would expect that person to be rewarded. And he wasn't. And there's a lot of hard work. I mean, I'm sure he had a lot of natural talent. I know he had a lot of natural talent, but he had to add a lot of hard work to that. And he did not get anything close to a just reward. Finally, I will close with somebody asked about the NCAA liking them or disliking them. I will close with a quote from Rick Pitino, who's a top coach, basketball coach in the NCAA. He's actually won the championship. He's now at St. John's. And here is what he said about the NCAA. It's on in early February of this year. Quote, "So I think the NCAA enforcement staff should just be disbanded. It's a joke, not because I dislike them, but because they're of no value anymore. Because just Tennessee will now take them to court. Virginia will now take them to court," close quote. So again, it's not about liking or disliking. They're a dinosaur. They make no sense in this modern world. And all the things that they made us think over the years about amateurism and not paying people and this and that and the other thing have finally been exposed.
Yeah, so both Ron and Jeffrey mentioned about digital gaming, video gaming, and so we thought it made sense for you to just be aware of the latest in that context. Just quickly, LeBron James was sued by a photographer who owns the copyright to this particular photo that you see on your left-hand side. He has a contract with the NBA to take photographs, and as a part of that deal, he has the right to register the copyrights that are taken, or register the photographs that are taken as a copyright. So he's sued for copyright infringement because LeBron James then took that photograph and separately posted it on his Instagram post. And LeBron James then countersued for a right of publicity violation, saying, no, this is my name, image, and likeness. You didn't have the right to use my likeness outside the scope of the game itself. Unfortunately, that case settled, so we never got any resolution out of it, and that's part of the ongoing struggle that many of us as attorneys are dealing with, because you don't have much to go on in terms of precedent yet. But hold on, it's coming. There's a separate lawsuit involving LeBron James and some of the NBA players regarding the use of certain tattoos in video games. The tattoo artists, and there's been a slew of litigation over this. One in particular, a guy named James Hayden, has argued that, yes, I did a tattoo on LeBron James, Kyrie Irving, Shaquille O'Neal, others, and I gave up the right to that to the player in exchange. I still, though, got a copyright registration because I'm a tattoo artist and I've got to make money. And so my artwork is registered as a copyright. And while I did relinquish that right to the player or the person individually, I did not relinquish that for the context of some video game merchandise, some video game that's been promoted in hundreds of millions of dollars. That takes the use and the misappropriation into a whole different can of worms, whole different ballpark. And the judge in a pending case right now dismissed 4, but kept in 2 of the copyright registrations of the tattoo artists, and they're scheduled to go to trial in April. I suspect it'll probably settle, but just be aware that there is still this ongoing debate and tension between social media, copyright, right of publicity. And with that, we still have time left for Q&A, if there's anybody out there. Yes, Miss.
Oh, yes. So, hi, my name is Destiny Aguilepo. I'm a 2L at Hustle. My question has to involve with sports betting and things of that nature when it comes down to NCAA athletes. I know that with the NFL, they do get a kickback and things of that nature. And I believe it would be the same for the NCAA since they do allow college betting for some places. I don't know if it's universal, but I was wondering, how does that actually affect the students?
Jeffrey?
The students are not entitled to participate in any share of wagering. And as far as I know, the NCAA does not regulate that. Whereas the NBA and the NFL have actually sanctioned it. And there are certain strategic alliances and partnerships that they have where they have given the rights to certain gaming institutions to actually monetize that. So those partnerships have been in place. I'm not aware of one with the NCAA yet, which doesn't mean it won't happen. But in theory, since the NCAA, as Ron has mentioned many times, has had this posture of preserving amateurism and the purity of sport, I think that may be a bridge that they're not there yet. But Ron, you may have some better intelligence than I do on this.
I think the sports betting is a whole separate issue. It really doesn't have to do with the name, image, and likeness, unless one of the sports betting companies uses it. But we've come full circle on that. The main people who opposed sports betting over the years were the professional leagues, the Major League Baseball, the NBA, the NFL. And once they lost that case, now they've embraced it. They're partners with DraftKings and the other big gambling companies. So, and the states, originally most of the states were against it on moral grounds. And now the way they salve their consciences is they say, oh, well, we're going to allow, for example, remote betting. You can bet from your mobile phone. So of course, if you're betting from your mobile phone, it's very difficult to screen how old you are, whether you have other problems, etc. And they say, well, what we're going to do is we're going to take that money that we get, and we're going to take a portion of it, and we're going to create a fund to help gambling addicts. So on the one hand, they create the gambling addicts. On the other hand, they're trying to cure them. So that's where we are today.
Anyone else? All right.
There is
Oh,
one
please.
comment that I want to make.
Please do. Please do.
And I don't know where this case lies, but I recall a swimmer, I believe from the University of Arizona, his name is House, had a lawsuit against the NCAA. And this lawsuit was actually based on retro pay that not going forward, but he was a swimmer years ago, and his suit is claiming damages and basically, retro payment for the NCAA's use of his name, likeness, and image, as well as everybody in this class action suit. So that would have tremendous domino effects on back pay for decades, in theory.
Good point, good point.
Well, I think that the statute of limitations would take care of that, quite frankly.
We will find out soon enough. All right. All right. Well, thank you all for listening to us for now. Thanks, Ron.
All right, take care.